I'm really thankful to the management of DOCTORSCON who have invited me to say something about a topic which is really a nightmare for the doctors to discuss. Medical negligence, and to cope with the cases or complaints of medical negligence is a nightmare for the doctors. And this is a topic about which the doctors are very much little aware of this. The reason is that the doctors don't know law, and whenever the cases of medical litigation goes to the courts, the judges and the lawyers, they don't know medicine, and that is the reason. And one more thing which is complicating these things is that there are no proper statute of medical negligence in Pakistan, and there are many laws which need to be there for treatment purposes or to protect the patients and to protect the doctors, but there is no statute for these things. Like there is no Mental Capacity Act, there is no Abortion Act, there is no Medical Negligence Act. So really we are getting dealt with the criminal law by the medical negligence, which should not be. So I will just go through few of the things about medical negligence. हमारे जब early adulthood के days थे, तो the patient used to believe that the doctors knows the best, and doctors treat according to their capacities the best. But ये अब situation खत्म हो चुकी है, and now most of the patients, they come to us for second opinion because they had themselves consulted first to the Dr. Google, and then they come. This is my hospital where I work. I just want to emphasize one thing to particularly the organizers of different conferences, that the people who come from periphery, they should also be given the forum to address or to talk about the problems of medicine, to practice medicine in the periphery particularly, because I had felt that in Pakistan, only the major cities, they have got the hold for all type of academic activities in medicine, or I don't know about the other subjects, but in medicine it is only and only the major cities which are occupying which are getting the major share here. I will just introduce you with a few terms because the time constraint is there. I will define what the medical negligence and malpractice is, and how it is different from professional misconduct, and how a contributory negligence can give a defense to the doctors, and what is vicarious negligence. You know कि medical negligence क्या है? All the cases doesn't come in medical negligence, but medical negligence is when a doctor is expected to act below the standard which is expected out of him. Medical malpractice and medical negligence is used interchangeably, and there is a lot of definition in the Wikipedia or in the medical textbooks, but the crux of these definitions is that whenever a doctor acts below the standard which is expected out of him, that is called as medical negligence. And medical negligence can be because of act of commissions, that someone has acted improperly, or these can be the act of omissions, that a reasonable person has to act in that situation but has not. For example, a patient with a chest pain comes, and if somebody has not carried out ECG, this means that he has done the act of omission. Now, in cases of medical negligence, the burden of proof lies with the patient to prove that the medical negligence has occurred. And the burden of defense, that is to prove that the doctor is innocent, that lies purely on the doctor's shoulder. To prove that there is a medical negligence, we have to satisfy the 4 Ds. The first is that the doctor owes a duty of care to that patient. And this is not difficult to prove, because if any patient who comes to a hospital, whether it is a public or private hospital, and then he has registered in that hospital for checkup, the duty of care that starts from that point onward. The duty of care starts from that point onward mean that the duty which is performed by the receptionist to guide how he has to guide the patient, that is also included in that. then seeing the patient, then investigations, carrying out treatment, and then even the after treatment, and overall what the medical healthcare management is there, that all include in the duty of care. And the patient has to prove that the doctor has breached the duty of care, mean that the doctor has acted below the standard which is expected out of him, and that is not only sufficient to prove, the patient has to prove that some damage has occurred. If the doctor has acted below the standard but damage has not occurred, this will not be a medical negligence case which can be initiated by a patient against the doctors. I am not talking about the regulatory bodies. And this breach of duty should cause that damage to happen. If the breach was there, the patient suffered damage, but that damage was because of something else, even in those cases the medical negligence cannot be proved. But in our courts, this 4D is not followed. The reason is that in our courts, the cases of medical negligence are dealt with like a criminal cases, and to some extent, sometime as the civil cases. I want to introduce this term, and this is a legal term which is in Greek, that is res ipsa loquitur, that is the thing speak itself, means that if some accident has occurred, just the occurrence of that accident means that negligence has occurred. Here there is no need to prove that negligence has occurred, because it is the domain of common sense or common knowledge that negligence has occurred. And the example of this is this one, that if the doctor has left some instrument in while operating inside the abdomen, and certain other things like wrong patients, wrong site, and these things are also under the res ipsa loquitur. The professional misconduct is different than medical negligence, because in medical negligence the court can summon a doctor in civil or criminal jurisdiction, but in medical ethics only the regulatory body will call you, and the professional misconduct or the ethical misconduct mean that the person is not acting according to ethics. And what the ethics is, these are the principles, these are the values, these are the conduct, that is the honesty, that is what makes the person character. If somebody is not acting according to the character which is expected out of a medical professional, this means that he has violated the ethics, mean he is guilty of professional misconduct. Even if somebody has deceived some person in any other thing, even that means that the doctor's misconduct or professional misconduct is there, because the doctor has to be a very honest, very truthful person. In GMC, if you see that if some doctor is caught traveling without ticket, their GMC certificate or GMC registration can be cancelled. If you have constantly or continuously you are in habit of parking at the wrong place, you will get a notice from GMC also. This means that the doctors are needed to be of a very good character, and very good honesty level should be quite high. And the cases of professional misconduct are dealt by PMDC, and according to that they can even suspend the license to practice or revoke the license of practice. And the Court of Appeal in these cases is the High Court or Supreme Court in our cases. This term I also want to introduce, because here just I want to tell you that what the medical negligence terminology is there, because I had conducted a workshop in Rawalpindi Medical College, and there I come to know, because that was a 6 hours long workshop, and the faculty members told that many of the terminologies they were not clear of. So I am sure that many of the doctors are not clear, because this subject is completely new in Pakistan. Vicarious responsibility means that the institution or the hospital can be held responsible for the negligence or the misconduct of his employees. This means that the respondent superior means that let the master answer about the wrongdoings of his subordinates. And this is same as the captain of the ship doctrine is there, and 3 conditions should be met, that employee-employer relations. That is why you have to prepare the job description of your employees in the hospital, because if that jobs come under their job description, then that negligence will be vicarious negligence or liability. But if you had not given him that permission, and if that person is doing, then he himself will be liable. That is the importance of making job description in your own hospitals or in your setups. There are certain defenses which are there against medical negligence. Calculated risk, that complications will happen whatsoever precautions you may do, and contributory negligence if the patient has not followed your instruction, but that is a partial defense, not a complete defense. And in Pakistan, these are the forums where the cases of medical negligence can go, from departmental inquiry, PHC, up to higher courts and so on. Dealing with medical law, as you know that prevention of the accident is better than the management of accidents. The things you do is never guarantee a cure. Please do not make overconfident prognosis. Do not do procedures which are beyond your own skills or qualifications, and do not criticize other professionals, because that can create an overall professional dishonesty, or our image as a professional will be tarnished. And things to do is take the consent. And here in Pakistan, it is the family, because most of the time the patient is kept outside the communication circle of patient-doctor relationship. But in Pakistan, the family and the patient, they are the same. Keep full, accurate and legible records, confirm diagnosis with lab investigation, keep yourself updated, and exercise care in selection of your assistant and delegating them the duty, and establish a good rapport with the patient. And if some negligence has occurred, please do the frequent follow-up of that patient. And facing lawsuit means don't panic. Always take advice of some of your seniors or the person who is involved in that. Read some law about medical negligence, because lawyers don't know the medicine and we the doctors don't know the law. And try to settle these cases outside court, because ultimately most of the cases, these are settled outside the court. So before the cases go to the court, always please settle it outside. Now this is the last slide, and this is the most important slide, that the patient cannot prove the negligence because of this law. And I am sure that many of the persons, they must not be knowing this law, which is the major defense with us, that if a person has done something and other body of medical experts in those circumstances, they say that we would have done the same thing if the same circumstances are there, then that doctor is not guilty of negligence, even if the harm has occurred. So this was a very short introduction about medical negligence, and with this I thank you all.